What's up, everybody? Stephen Lefkoff here, Lefkoff Law. I got an interesting call this morning from a dealer in the GIADA Association who had a good question about credit, what I call turn-down notices or adverse decision notices. And the question was, if you're not running the credit, do you still need to provide the adverse decision notice? All right, so for example, you are taking credit information, you're sending that information over to, say, Capital One or a host of any other loan companies, right, to get a decision on whether or not they will provide a loan or approve that customer's credit application on a deal, and they turn it down. Well, technically, because they are the entity that ran the credit, they are the ones that are responsible for sending the adverse decision letter to the customer. That said, I always recommend that my clients send an additional notification saying that they provided the information to Capital One and Capital One turned it down. Capital One, of course, being an example here, it's not obviously them every time. Because even though it may not be a legal requirement that they send the notice, it's always a good course of conduct to just cover your bases. It's something we talk about a lot. It's something I talk to my clients about a lot, that they ask, what does the law say? Okay, it's important. You're talking to a lawyer, right? You want to get legal advice. You want to know, what does the law say? But another piece of quasi-legal advice, I guess, is the business advice. The law might say one thing, okay, but there might be another thing that you may want to do as a business practice, so that in the event A, the law changes, or B, you get an aggressive plaintiff, they don't drag you into a situation that you just don't need to be dragged in. So that's a perfect example of one of these times where the law says, since you didn't run the credit, you didn't reject the application, you don't have the duty to send the adverse notification. However, it's probably a good business practice to do so. Now, a lot of your software systems may not even allow you to prepare such a notice if you don't run the credit. That's fine. If you're limited in that way and you don't have an option and you can't send the notice, okay, so be it. You don't have a duty to do so anyway. However, if you have a method or staff or some way to send that kind of notification, it's always a good practice. Dear so-and-so customer, your credit was run by Capital One. It came back as denied. Capital One was unable to approve you. For more information, please contact Capital One. Your credit, the reporting bureau that they checked was such and such reporting bureau. You can contact them that way. Listen, this is not the law. The law doesn't require you to do this. The law requires you to do it if you are running the credit and you are the one making the credit decision. It's never a bad idea, though, sometimes, to go above and beyond what the law requires just as a business decision. So that's my recommendation on that. Do you have to do it? No. Is there a legal requirement that you do it? No. If you run credit and you are making a credit decision, let's say a buy here, pay here, for example, then do you have to do it? Absolutely, no question about it. If you are running credit and you have an adverse decision, so you are denying a credit application, you are denying a sale to a customer because of what you find on their credit application, you absolutely have to send that kind of notice. Actually leads me into another point. If you do not run credit on that customer, because there's information contained in their credit application that you know right off the bat they are not going to get approved. For example, their monthly income is $1,000, let's say a month, and you know, because you've been in the business or because you're a buy here, pay here that approves your own deals based on credit, you know, hey, this is not going to pass muster even if they have an 850 credit score, right? It doesn't matter if their income is that low or at that number that it doesn't meet your requirements, your income requirements, and you don't even run credit, then you don't have to send an adverse credit notification because you're not making a decision based on credit. You're making a decision based on information provided in the credit application. Very different, right? Because your adverse notice says something like, you have applied for credit with so-and-so dealership. We have run your credit and your credit and the deal was denied, the underwriting was denied for this reason, right? Or based on information we found in your credit history. For more information in your credit report and for a copy of that report, you can reach out to Equifax or TransUnion or whatever it is entity that you used to pull credit. That's what your credit turn down notice says. Okay, that obviously would not apply if you never pulled credit. Okay, so if you never actually pulled their credit, then you have no need to provide that notice because your decision, the turn down itself, was not based on the customer's credit. This is a whole sticky issue. There's a lot of new law and a lot of aggressive plaintiffs and plaintiffs' attorneys seeking Fair Credit Reporting Act issues. So something to be very careful of, especially if you are a buy here, pay here dealer in Georgia where you are running credit and you are making decisions in-house based on the consumer's credit. So be mindful of that. Steven Lefkoff, Lefkoff Law. Reach out to me, Steven, S-T-E-V-E-N, at lefkofflaw.com, 404-482-2228, www.lefkofflaw.com. That's LEFKOFFLAW.com. Catch you next time.